Hello and welcome to today's program titled Midterm Reactions to Dobbs. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. Just look for the Q&A tab. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to Diane Digert, a partner with Seyfarth Shaw. Diane, you may begin.
Thanks so much, Bill, and welcome everyone to our third installment of our webinars by our Reproductive Health Law Advisory Team. And I'm joined today with my partners Sam Schwartz-Fenwick and Ben Connolly to talk about midterm reactions to Dobbs. And we definitely have enough to fill the time here today. Before we start, though, I have to read you our legal disclaimer. This is to let you know that this presentation has been prepared by us for informational purposes only. The material discussed during the webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. Content is intended for general informational purposes only, and you're urged to consult a lawyer concerning your own situation and any specific legal questions you may have. So with that out of the way, our agenda today, we're going to first kind of discuss the lay of the land, the impact that Dobbs seems to have had on the 2022 midterms, and Sam's going to lead us through that. Ben's going to talk about possible congressional and executive action. I'm going to talk about state outcomes and possible state actions, kind of morph those together. We'll go back to Sam for enforcement actions, and then we'll wrap up with some information on Seyfarth support. And that's the time where you'll get your CLE code, so be sure to stick around till that section. So I am now going to hand it over to Sam. Take it away, Sam.
Awesome. Thank you so much, Diane. And one other point, just so folks know, at the end of the webinar, we are going to take questions, but if folks want to be typing in their questions as we go, often if you don't type it in right away, at least speaking for myself, I forget it. So feel free to type in questions as they come through. So let's talk about the impact of Dobbs on the midterms. I was writing with Ben and Diane last week before the day before the election, because we wanted to plan, the webinar, and I said, let's hold off a couple days so we can see how big the red tsunami was. And not to bury the lead, but there was no red tsunami. And there are a lot of reasons potentially why that's the case, but definitely a huge one, I want to go through the data on this, was the impact of Dobbs. Now, everything was moving in the direction of there being a truly historic win by the Republicans. Even in the best of circumstances, where you have a popular president, in the midterm elections, the party of the president in power generally loses around 28 House seats. When you have an extremely unpopular president, as all polling is certainly showing is the case with Joe Biden, you would expect a loss of 43 seats. And add on to that, the highest inflation in 40 years, a massive increase in crime, massive geopolitical tensions. All the markers were in place for a big shakeup. But while they're continuing to count ballots, what we know for certain is that the Democrats have kept control of the Senate, and if Republicans take the House, it will be by one of the narrowest margins in history. But not only that, at the state level, across the country, Democrats either were able to hold on to their same level of support or actually build on it. All of this really defied expectations. I think there was, a less than 3% chance of this being the outcome of the election. But this still begs the question, okay, so the Supreme Court issues a decision in June. This is November. What's the cause and effect? So let's dig into that. So the exit polls that were conducted, and this is an amalgamation of a few different sources who did exit polls, but they both tend to reflect that about 60% of folks who actually voted we would put in the pro-choice camp. They believe abortion should be legal in all or most circumstances, and 27% of voters said that abortion was their most important issue in voting. Now, of that 27% who said that, they favored Democrats by a margin of 3-1. And you can get a little bigger sense of this, and I apologize for how small this graphic is, but you'll be able to see it more when we send out the materials. It shows that in 2018, before we had a few additional folks on the Supreme Court, the key driver of bringing out the base for Republicans was abortion. 79% of Republicans said that abortion played a role in how they voted, compared to 19% of Democrats. This time around in 2022, the numbers were reversed, with 19% of Republicans saying it was a key driver of what brought them out to vote, and 77% of Democrats saying this. So what this is really demonstrating is that this was a real driver and motivator to get people to the polls, which in an off-cycle year where your president is in power, that often doesn't happen. And this could be a real reason why we saw the results turn out the way we did. So even more than that, 57% of Democrats versus 23% of Republicans said that Dobbs impacted their vote. Now, when Diane talks, we're going to get into the various state ballot measures that were on the ballot across the country last week. But what you can see just looking in, Michigan, is that roughly 60% of Democrats said that Dobbs had a major impact on their decision to vote. So I think there was a real fear, especially in states where abortion was on the ballot, that if you didn't get out to vote, it could really impact, the pro-choice future of your state. And so that was really seen. A cool graphic that Ben put together from CNN was just showing in all the various battleground states how big a role abortion played, especially when comparing it with pocketbook issues like inflation, that it really went toe-to-toe and even in some states exceeded the impact it had on getting out the vote and acting as a driver. And this is really important as we're talking about what legislative and executive actions, as well as what types of judicial actions are going to look like in the next few years, because it at least appears from this data that a solid majority of Americans do not want further restrictions on abortion. All that being said, there's really an open question about what impact taking an anti-choice stance will have on politicians. The pundit Ross Douthat had a really interesting article on that point in the New York Times over the weekend. That it's short, and I recommend reading it. But he pointed out that, it's impressive if you look at the victories of the pro-choice camp throughout the country. But in those states where abortion has already been restricted, either in the past year or pre-Roe, what you've seen is there was no impact on state legislatures or on governors based on how they voted on these issues. The heartbeat bills, for instance. He looks at the governors who signed the fetal heartbeat bills, which is really when the nervous system starts sending signals. But if you can't perform an abortion after that date, he said all of those governors still won. So I think what this is showing is, it might be a priority among voters, but time may tell how impactful this will be in terms of drawing out voters in future elections. So with that background, I wanted to flip it over to Ben to get in some of the nitty gritty of what we can expect from Congress and the president in light of the really stunning election results and the impact Dobbs had on them.
Yeah, thanks, Sam. And I mean, before we move on to this point, I know we got a question about, what about Arizona, which is a state that recently, if I'm remembering correctly, the courts upheld a pre-statehood abortion restriction, but is a state that narrowly at the Senate and governor level went Democrat. And I think a key point here is that it's been interesting to watch political pundits talk about this election because so often they want to pick a general theme that govern the entire population of the United States, right? But here, I think that's very hard to do because there were state by state and region by region variations that defied the norm. And you can certainly look and try to pick trends. Like you can look at Michigan in this chart Sam's showing, right? And say, well, look, abortion was directly on the ballot, right? If Republicans came out in droves and voted in favor against the constitutional amendment and for the Republican candidate for governor, it is a very distinct possibility that now or in the near future, abortion would be prohibited or severely restricted in the state of Michigan. And you see there that abortion was a top issue amongst the voters, and it came out in droves and voted in favor of the constitutional amendment for the incumbent Gretchen Whitmer for governor, which seems to, for the time being, stave off the possibility that Michigan will meaningfully restrict abortion access beyond current restrictions. But I mean, like
another point,
others, so like Pennsylvania too, right? Oh, go ahead, Sam. Sorry.
Oh, I was just going to say an Arizona specific issue, and this gets to Ben's point about how state by state we need to be, is that the governor of Arizona was term limited. And so you had two new people running for governor, and the Democrat who ultimately ran, a big part of her race, there were a lot of focuses on it of the positions taken by her opponent, but a main one was the right to choose, and that there would be an impact on the legal landscape in Arizona and the legislative landscape in Arizona if you voted for the Republican candidate. So even though it wasn't a ballot initiative, it became an issue for a lot of voters. And I think that's why you see such a high percentage of Arizona voters saying this is what brought them out to vote, is because there was fear based on, especially the governor's race, for there being a change to the status quo.
We've talked about this a couple different ways internally, and you can certainly try to make the case that there is a trend that anywhere where a ballot initiative or the elected officials would, the vote would result in greater abortion restrictions, the Democrats performed better. There are, and then in other places where it wasn't sort of directly an issue, right? Like you look to New York, which has a trifecta majority, Democrat majority, or you look to Florida, which has a Republican trifecta, but was a state, at least before the election, where DeSantis had largely drawn the line and said, we have a 15-week restriction, but we're not going more restrictive than that. And Diane will tell you about where things have trended in that direction since the election in a moment. But and say, well, look, if abortion was materially an issue one way or another, that seemed to have favored the Democrats, whereas if abortion was not an issue, the historic electoral trends in the president's first midterm cycle prevailed, which is the party in power is punished, right? But I mean, it's hard to say, in all 50 states that trend held up. There certainly seem to be undertones of that, but we're all just left to look at, exit polling and speculate, et cetera. But as Sam noted, there certainly seem to be some undertones of a trend there where if abortion was perceived by the voters as an issue on the ballot, that was a driving factor in the outcome. And by the way, I know we have a question about sort of what does this mean for companies, right? We're certainly, that is a significant portion of our agenda here, so we're going to get into that in a few moments. Yeah, right. So we now kind of know what the landscape is going to be. We don't know the specific breakdown. I mean, the House hasn't been called yet, but I think as of this morning, Republicans needed a single seat to take the majority there. But we know they're not going to have a significant majority in the House. The Senate has been called. We don't know the size of that lead, but we've got it down to one member. So we know the makeup, and it's going to be a divided government, right? And we know a couple things as a result of that. Number one was Republicans in the Senate had proposed imposing a nationwide 15-week ban on abortions, but with Biden in office, that would have required a supermajority by the Republicans to be able to pass that through to override Biden's veto. And we know Republicans will not have that supermajority, so that seems to be off the table for the time being for at least the next 2 years. Similarly, before the election, and even briefly after the election, when the outcome was still in dispute, you heard Biden state that the top Democratic priority following the election would be to codify Roe versus Wade. Yesterday morning, Biden conceded that it didn't appear that there would be the votes necessary to do that either. In the Senate, they're closer, right? And they could certainly get rid of the filibuster and vote to codify Roe versus Wade with only 50 votes. But you probably need 52 Democratic votes to overcome the resistance from suppressing the filibuster by Kyrsten Sinema and Joe Manchin. But it's sort of irrelevant what's happening in the Senate now because it looks like the Republicans will control the House. And it seems unlikely that even with a slim majority, the Republicans would take up the reins of that initiative. Although interesting point, I think the Democrats in the House passed a law codifying Roe maybe a month ago, and had the Democrats had a greater majority in the Senate, query whether they could have taken the reins on that existing legislation and pushed across the finish line. But I think it's all hypothetical at this point because both houses are going to be so closely divided that any legislative action on the issue of abortion access is probably moot. It's probably a safe thing to say at this point. So in the absence of legislative action, that leads the executive branch and the administrative agencies controlled by the executive branch to take unilateral administrative actions to attempt to further the Biden directive that all agencies should find ways to protect and expand access to reproductive health. And so what does that look like? Sort of at we have some thoughts at the macro level, and then we're going to talk about some thoughts at the micro level from the perspective of how companies might be structuring or addressing their abortion travel benefits or medical travel benefits. At the macro level, what we have seen consistently and what we will continue to see is the Department of Justice and the Office of Civil Rights, a component of HHS, attempting to use the leverage provided to them under EMTALA, which is a federal law that effectively requires that healthcare providers provide medical services where the life or health of the individual is at risk, to attempt to crack down on state restrictions that may have a chilling impact on providers deciding whether or not to provide medical services. And Sam's going to talk about this a little bit as it played out recently. But we've seen a couple of instances of this already. I think that there was a DOJ investigation into some restrictions out west, and we're going to see this play out more and more where the administrative arm uses its investigative authority under EMTALA to attempt to lean on providers in states with abortion restrictions to, when it's a close call, sort of break the way of the woman whose life or health is at risk. In favor of providing the abortion services, notwithstanding the risks of those providers under those state laws. Perhaps the biggest result, sort of actionable result from this election is the Democrats holding the Senate, which will allow Biden to continue actively appointing justices to federal judicial appointment positions. So what we saw at the tail end of the Obama administration was that when Republicans held the Senate, Mitch McConnell, majority leader at the time, effectively shut down all judicial appointments, accruing a massive backlog, which were then subsequently filled during the Trump administration. And that's a critical point, right? Historically, the president has the authority to pick a judge, and then the Senate confirms, and usually they moved in lockstep absent extreme appointments on either side of the aisle. But the default for the last several years essentially has been the Senate and the presidency have to be held by the same political party for something meaningful to happen in that regard. So that's pretty significant. And the reason that's significant is because this is where all the battles are playing out right now regarding abortion restrictions, right, in the courts. Largely, there aren't sort of divided legislatures such that there is a debate at the state level about what to do. States are taking action, and then there are judicial challenges being brought in a variety of fashions. Sam's going to talk about some of these that will play out in the courts. So that is not something to be understated, the ability to continue with the sort of unfettered appointment of judges to federal positions. I know a lot of people are interested in EEOC action in this space. A little teaser here. Sam's going to talk about this later in his discussion, but that is certainly an area where I think we're going to see some administrative action in sort of a couple different directions. So the next piece we wanted to talk about was sort of micro level. And these are the things where sort of the benefits lawyers get in the weeds. And I think our final one might be cut off here, but I'll see if I can hit on it. So a couple things, right? One of the things we've been talking about for several months now is employers implementing travel benefits, travel medical benefits. And we've seen this take a variety of forms, specific to abortion, more broad-based. We've seen this targeted towards only people enrolled in the employer's health plan. We've seen this offered to employers' entire workforces. But we are operating here in an area where there's really a dearth of guidance, right? So it's just a bunch of lawyers sitting around noodling what they think the law says about X, Y, and Z. But the agencies have largely been silent on whether they agree with our interpretations. So some of the things that we would like to see out of the administrative agencies to cast some clarity in this space for employers who have attempted to implement these types of benefits. So at the IRS level, one of the things I think a lot of people were shocked about, it's been a longstanding interpretation of the IRS, but one that people didn't really focus on until recently, is the tax caps on tax-preferred travel reimbursement. And what we know is that generally speaking, for lodging, the IRS caps the tax-preferred reimbursement at $50 a night, which probably made sense way back when that was the going rate for hotels, but certainly not a rate that you can meaningfully access in this day and age. So I think a lot of people would probably like to see, for purposes of facilitating a smooth benefit implementation, an expansion of those IRS tax-preferred travel limits, which would just make life easier for employers, because I know a lot of employers are either imposing the cap or doing a split treatment where you provide $50 tax-free and a reimbursement on a taxable basis above that, which is, needless to say, administratively cumbersome. The second piece is that a lot of employers have been implementing these benefits for persons enrolled in high-deductible health plans, and there remains some uncertainty about whether a medical travel benefit would be considered disqualifying coverage if permitted before the employee hits their deductible under the health plan, such that their HSA contributions would no longer be tax preferred and would need to be kicked out of their HSA. So we think there's a decent argument to be made that this is insignificant benefits in the nature of medical care, just like an EAP would be that wouldn't disqualify your high deductible health plan. Maybe even more so, because really you're not reimbursing, you're not talking about reimbursement for the actual medical services, you're talking about reimbursement for travel. But that is not, I think, the prominent view within sort of the healthcare community. And so I think most people are structuring their benefits such that it suppresses reimbursement for travel benefit until the individual hits their deductible under their high deductible health plan. So a statement from the IRS, at least confirming treatment, but certainly one that would say, no, if you're offering this benefit and it's within 9Z parameters, we don't consider that to be disqualifying coverage for these purposes. That would be helpful from a plan administration standpoint. From the Department of Labor, I know when we talk about state enforcement actions, there's been a lot of consternation about, if I've implemented this as part of my ERISA plan, can states even come after me, right? Both from a civil perspective and from a criminal perspective. It would be, I think, helpful from a plan sponsor perspective for the DOL to come out with field assistance bulletin, technical assistance memorandum, whatever form they want to take, providing that ERISA preemption does apply if you structure the benefit X, Y, and Z way. I think that would provide plan sponsors with some comfort who have set up these types of benefits, certainly from a civil enforcement standpoint. But again, generally criminal laws aren't preempted by ERISA, but to the extent that they attempt to start passing laws targeting travel benefits, that arguably wouldn't be a criminal law of general applicability, and there would be a stronger take that would be preempted by ERISA. But again, you always feel more comfortable in that context when you have a DOL statement confirming your thought there, because ERISA preemption, the only way you know you've got it is if somebody comes after you and you assert it as a defense. It would also be helpful if the Department of Labor could clarify whether and to what extent a standalone travel benefit could constitute an accepted benefit. Background here is that generally speaking, medical services are considered group health plans, and under the ACA, any group health plan has to cover a long list of preventive services at 100% cost sharing to participants. A standalone travel benefit, if considered a group health plan, would not meet that criteria because it's only reimbursing travel. It's not reimbursing colonoscopies and mammograms and the like. But if the DOL came out and said, hey, if you structure a travel benefit, we think this is an insignificant benefit in the nature of medical care, and as a result, it's an accepted benefit and not subject to the ADC end date, that would open the door to employers structuring this on a standalone basis and potentially offering it not just to health plan enrollees, but to their broader population. Final two pieces here, HHS. Sam's going to talk about the EMTALA guidance. We saw from HHS just maybe yesterday that they are going to start prioritizing placement of immigrants in states that don't have abortion restrictions. And then the final one, although we can't much now at this stage, is the battleground regarding abortifacient drugs. The FDA's position is if they've approved a drug, states don't have the ability to restrict access to those drugs, but states are pushing back on that. So I think that's probably going to be the next battleground that we see. And with that, I'm going to pass it to Diane to talk about some of the things that are happening at the state level. I think you're muted, Diane.
Thank you. Knew I couldn't get through it without messing up the mute button. So thought I'd start with a little refresher as to where we were before a week ago. As we talked about in one of our prior webinars, the battleground on the right to either restrict abortion or access abortion care or reproductive health care generally has moved from the federal government down to the states, both like on the legislative front as well as on the state constitutional front. And again, before this past election last week, no state constitution had explicitly included a right to abortion or a right to other reproductive health care pre-November. 11 states have a right to privacy explicit in their state constitution, which you don't find in the federal constitution, and they're listed here on the left side of the slide. On the right side of the slide, certain state court systems, courts in certain states have determined that abortion is a protected right by the state constitution based either on that right to privacy in the state constitution or a right to self-determination. You have a list of them here, kind of highlighted Kansas because of what happened with Kansas in August. And then there are 4 states listed here where in that state constitution, let me go back there. Stop playing with my slides, guys. In that state constitution, 4 states where where abortion is explicitly not protected: Alabama, Louisiana, Tennessee, and West Virginia. So before last week, no states it is explicitly protected, but 4 states where it is explicitly not protected. So what happened? There's like a little mystery bug thing with a slide forwarder. I swear my hands are not touching it. So a refresh on earlier ballot initiatives, so before last week. So Mississippi, North Dakota, and Oregon, all pre-Dobbs even, had ballot initiatives that voters rejected. And in those 3 states, all those initiatives would have defined life as beginning at conception or otherwise severely restricted access to abortion care. And all 3 of those states, those ballot initiatives went down. Then, as we know, in August, the Kansas voters were presented with a ballot initiative as to whether or not to explicitly remove abortion as a protected right under their constitution. The Kansas Supreme Court had previously found that the Kansas Constitution did provide a right to seek abortion services under the right to privacy. So the ballot initiative was there to kind of pull that back from what the state court had determined, and the voters rejected that. So that's where we were. And then this past week, 5 additional states actually put on their ballots referendums that asked voters whether to approve greater abortion restrictions or to approve protections for abortion care. And as we'll go through, all 5 of those voters in all 5 of those states wound up going in the direction of having greater protections around seeking abortion care. So I'll start with California out there on the West Coast. California already had very, statutes in place and protections around abortion care and privacy for abortion care and those sorts of things. But nevertheless, they put a referendum on their ballot. I think it's Proposition 1, which provided that the state shall not deny or interfere with an individual's reproductive freedom in their most intimate decisions, which includes their fundamental right to choose to have an abortion and their fundamental right to choose or refuse contraceptives. And they made it clear that this was in addition to the right of privacy and equal protection that's already in the Constitution. So this is not narrowing those protections, but it's in addition to it. That passed, as you'll see here, by a margin of 66 to 34%, with about 70% of the votes counted in California. And then moving over to Vermont, go to the opposite end of the coast, opposite end of the country, opposite coast. Vermont also put a referendum on their ballot that would add a constitutional right to bodily autonomy. It reads that an individual's right to personal reproductive autonomy is central to the liberty and dignity to determine one's own life course and shall not be denied or infringed unless justified by a compelling state interest achieved by the least restrictive means. So that passed by an even wider margin, 77% to 23%, with 95% of the votes counted. And then moving kind of to the middle of the state, Michigan had a similar ballot on their referendum on their ballot, Proposition 3, and that would also amend the state constitution to provide a right to reproductive freedom, including all matters related to pregnancy, birth control, abortion, prenatal care, and childbirth. That also passed by a closer margin, 57% to 43%, again with more than 95% of the votes in. It is interesting to note, and I think Ben mentioned this earlier, that in Michigan, the statewide ticket, the offices of governor, attorney general, and secretary of state, which were all very hotly contested, all those incumbents were voted back into office, and they had positions that were consistent with the referendum. So, people weren't splitting their ballots among those two, the referendum versus the office holders. So Montana, moving on to Montana. Montana took a little bit of a different tact. Theirs, instead of a constitutional amendment, was a referendum that would actually just put in place legislation. And that referendum, that proposed law would declare that a legal person is any infant that was born alive at any gestational age. Now, note that there is already a federal statute that dates back to 2002 that basically says that, the Federal Born Alive Infant Protection Act. The Montana statute would have gone further by criminalizing healthcare providers who didn't take, all possible actions to save the life of an infant who was born alive, even after an attempted abortion. And those criminal actions would be accompanied by, $50,000 in fines and up to 20 years in prison. The medical community in Montana was very energized against this legislation and campaigned strongly against it. They believed that it would have forced doctors to provide resuscitative care to infants that had no, had a fatal prognosis, that had no chance of surviving, despite the wishes of the parents. They were afraid that if they were forced to provide this care, it would be in lieu of providing palliative care, to help that child suffering. So that measure, based in no small part on that initiative by the medical community, that also failed by a margin of 53 to 47%, with the vast majority of the votes counted in that state as well. And then finally, we have Kentucky. Kentucky had a constitutional amendment on their ballot. This was in the negative, so unlike Michigan and Vermont and California, this was phrased in the negative. So this tried to explicitly exclude the right to an abortion or the funding for an abortion. And if you remember, Kentucky had a trigger ban in place that if Roe had been overturned, restrictions would automatically be triggered to restrict abortion access, except for very narrow exceptions for medical emergencies. And the ballot initiative was trying to make it clear that the state constitution would not be required to protect abortion access or funding of abortion, to make sure their trigger law could remain in place. And the voters rejected that amendment by a margin of 52 to 48%, again with over 95% of the vote counted. So, what does that mean in these various states? Starting with Kentucky that we just talked about. In Kentucky, there were a number of cases that had been challenging that trigger law. If the ballot initiative had succeeded, it really would have mooted those cases, because then by constitution, and statute, abortions would have been restricted. So those cases will be able to continue now because that ballot initiative failed. So we'll be monitoring those cases in Kentucky. In Michigan, there was a pre-Roe statute on the books, which dated back to, I think, the 1800s, like 1865 or something like that, that the GOP legislature was trying to say was in place, and the Democratic governor was trying to say was not in place, and there were lawsuits going on around that. The passage of the amendment to the state constitution in Michigan will pretty much guarantee that pre-Roe statute is going to be off the books in Michigan. In Kansas, remember, Kansas was the state that had their ballot referendum back in August. The battle really wasn't over, though. But the Democratic governor was reelected in that state. The GOP, though, has won a veto-proof majority in the legislature, so the Democratic governor can't block legislation. Problem in Kansas, though, for the GOP is that you have state Supreme Court cases that said there's a constitutional right to abortion. You've got a ballot initiative that declined to remove that interpretation of the statute. And most of the Supreme Court judges in Kansas won re-election, I think 5 out of the 6. So it's likely that the court system would still stand in the way, and the Constitution would still stand in the way of putting greater abortion restrictions in place in Kansas. In Montana, another state who's had the ballot initiative for their legislation, the GOP won both the governor's house as well as the legislature. But their efforts, kind of similar to Kansas in a way, their efforts to ban abortion have been blocked by the Montana Supreme Court consistently since 1999. Now, as the governor and legislature appoint new judges to the court system, it's hard to say how long that will last, but that's the situation we're in now in Montana. South Carolina, just an interesting note, the GOP within South Carolina has been conflicted. The House and the Senate have different visions as to what restrictions they should put in place with respect to abortion. And the GOP does control the legislature, but again, they're conflicted. Basically, the House declined to reconvene in a special session where they would have taken back up further restrictions on the restrictions that already have in place. So I think what we have now in South Carolina will stay status quo. Texas, as we know, we talked about the GOP won statewide, all their offices. We also know that Texas has been aggressive about trying to enforce their restrictions with their statutes and statements made by a contingent of GOP legislatures in the state, including, as we talked about in a prior webinar, writing to several private employers and saying that their travel benefits would be illegal in Texas. So, that may embolden their enforcement efforts that we see going on in Texas. Wisconsin, also an interesting state. The Democratic governor won re-election, Tony Evers. He'd been standing in the way of putting in place more restrictions on abortion in that state. The legislature kept passing restrictions and the governor vetoed them, and they didn't have a supermajority to override the governor's veto. They were hoping, the GOP were hoping that they would get a veto-proof majority in this election so that they could override Evers' vetoes. That did not happen. They do have a majority, but same old. So that will pretty much stay in place in Wisconsin with the Democratic governor standing in the way of the legislature's activities there. A couple more to talk about here. Florida. Whoop. Hold on. Why is this only happening to me? Florida, as we know, the GOP in Florida also, like Texas, won statewide office. Florida's interesting because it's really not, abortion remains legal in Florida up to 15 weeks, and the state court system have found the Constitution in that state protects the right to an abortion. And as I think Ben mentioned earlier, maybe it was Sam, Governor DeSantis didn't really seem interested in putting further restrictions on in Florida. But since the election, there's been discussion with the legislatures that they do want to impose further restrictions in Florida. There's talk to us down to 12-week or even down to 6-week restrictions on abortions. Of course, they still face a state court system that's held that their Constitution protects the right to abortion. The court system in Florida has become more and more conservative over the years as new judges have been appointed to the state court system. The other interesting thing in Florida, there's at least 2, maybe more cases brought by rabbis in Florida claiming religious discrimination with respect to these restrictions on abortion, because that is not what their faith says that people who follow their faith can do, and therefore discriminates against those of the Jewish faith. So it's kind of an interesting, those are interesting cases there that we'll need to follow in Florida. In Ohio has already been a state that has fairly severe restrictions in place. The GOP won the governorship, but also all seats that were up for election on the Ohio Supreme Court. So the GOP won all those open seats. There's also another vacancy that the GOP governor can fill. So there's a 6-week abortion ban right now in Ohio that's been blocked by a lower court in Ohio, and the thought is that when it makes its way up to the Supreme Court, that will be overturned. That ban will be overturned. So that's a quick look around the country at what's going on in various jurisdictions. So I'm going to turn it back over to Sam to talk about enforcement efforts.
Awesome. Thanks, Diane. That was so informative and interesting. I saw we have a question from Samantha that I just wanted to flag right now. It's, I think Diane touched on some of it in terms of after the election, are we going to see more enforcement from from states? A number of states, including Texas being the most prominent, have given their state prosecutors the right and tools to go after certainly providers of abortion in some states, even when they reside outside of the state, to potentially look into criminal violations for someone receiving medical abortion pills through the mail, and also taking very aggressive stances to pull medical records. So all of those things are in the books right now. Between Dobbs and the
Hey, Sam.
election. Yep.
On Texas, can I just add that California, and I don't remember if we talked about this at a webinar before, but Governor Newsom enacted 2 bills, I think purposely setting up a states' rights battle with Texas that basically forbid providers in the state from providing any information to out-of-state law enforcement. Someone, I think it might have been Samantha, brought up the Facebook turnover of data, trying to make that, not available to happen in the future. So it'll be an interesting kind of state rights battle that those new statutes in California have set up, which we might see soon.
It is, and just so everyone knows what happened with that Facebook case, because it hasn't really received a lot of news. I mean, it's received some, but it kind of receded. But a woman in Nebraska was accused of having helped her daughter get an illegal abortion at 23 weeks. And the police, in doing their investigation, issued a subpoena to Facebook of this mom and daughter's Facebook chats about how her daughter could get an abortion. And so that was turned over as evidence. There was a huge outcry, and Meta, the parent of Facebook, said, our typical practice is to hand over, when we get a government subpoena, we comply. But here, if we'd known it was about, abortion, we would have done something different. But I think what Governor Newsom is trying to put in place is not to leave that to happenstance or public relations, but actually make it like, no, under the law, this is what you need to do. And that it really would create that states' rights battle of what does an employer do when they get a valid subpoena from Texas, and but they also have to comply with the law in California. And so I think that really puts the issue to a head. The broader issue, though, of these enforcement actions is we haven't seen as many of them as we thought we were going to. Since Dobbs, Illinois, where Ben, Diane, and I sit, has seen a deluge of women coming from out of state to have safe abortions in Illinois. That puts certain medical providers in Illinois at risk for having their records subpoenaed and potentially having them investigated. That really hasn't happened. And I think a lot of this is because there's been a skittishness among the prosecutorial arm of these states of going against providers in other states and going against individuals in other states. I think there's been a reluctance to do it given public opinion. That could change, though, at any time because those powers are on the books. What we have seen, though, are a number of court challenges that are going after the attorney generals in various states, and also going after hospitals that are refusing to provide services to women who need emergency care. So I'm just going to go through a few of those. First is this Bernard versus Rokita case. Rokita is the attorney general in Indiana. Bernard is the name of the OBGYN who performed an abortion for the 10-year-old girl from Ohio who was raped. You'll recall this was a big, media circus around this. Initially, it was claimed, oh, this never, this isn't a case, this is fake news. Then it came out that no, in fact, it was real, but what was something nefarious going on. So a huge number of people sent in complaints to the Indiana Attorney General to challenge the license of this Dr. Bernard. The Indiana Star has reported, though, the Attorney General readily could have disposed of the investigation because it was clear that the doctor had filled out all the necessary paperwork she was required to submit in Indiana. The Indianapolis Star just FOIA'd it. They figured out this doctor did everything right. Nonetheless, this investigation went forward. And so the doctor is suing the Attorney General for overreach. And it is a case that certainly has large implications for medical providers in states where there's at least some latitude for performing abortions. Her argument is, as long as my patient or I didn't complain about what happened, and as long as I jump through all the procedural hoops, you have no business, the state, investigating me. That's why we have licenses that are, licensing boards and things like that that are outside the power of the state. But otherwise, the state could be emboldened to, in her words, go on witch hunts. So it'll be interesting to see how that case shakes out. It's being closely watched by the medical community, who obviously want a ruling in the doctor's favor to ensure the broadest protection possible for doctors. Another case we have is that Ben touched on. It's arising out of Missouri, and there's a federal investigation and a state investigation under EMTALA, which is the Emergency Medical Treatment and Labor Act. And so what that act is saying is hospitals who receive Medicare, which is most hospitals, they need to provide emergency services to pregnant women, including performing abortions if it's necessary for the health of the mother. After the Dobbs decision, very shortly after, at the beginning of July, HHS sent out a strong letter saying, remember us, guys, EMTALA still exists. You can't, I don't care what the rules are in various states, you still need to comply with federal law on this issue to the extent you receive Medicare funding. That said, there have been a number of cases, only one of which has been reported to date, but there are a number of active investigations throughout the country in which the federal government is investigating violations of EMTALA, where a woman went to the emergency room because her life was endangered due to an issue with the pregnancy, and she was turned away. The turning away is in large part due to medical staff fearing that they'll be prosecuted under state law if they treat the woman who comes in because of a divergence in belief of what is truly an emergency. But so this is really something to watch. Something else that I wanted to flag that we've seen really play out over the past few weeks is a dispute within the EEOC in terms of travel benefits. A former GC of the EEOC sent a letter out to a number of employers saying your travel benefits for abortion treatment violate the Pregnancy Discrimination Act because you're not providing the same travel benefits to women who or individuals who complete their pregnancy and give birth. There was also a claim that it violated the Americans with Disabilities Act because it wasn't generally provided for other benefits. The EEOC sent a letter that said, look, this is from a private citizen. She doesn't speak for the EEOC. But within a week of that, one of the Republican commissioners of the EEOC said that she is going to be filing individual charges on this issue for the same reason that were laid out by Ms. Gustafson. Now, this is showing that there's certainly a split in the EEOC of how this issue should move forward. But I think it's certainly very premature to think that the EEOC is going to start bringing enforcement action or initiating litigation targeting employers. I think what's more likely to happen is that you'll have individuals who say they didn't have access to a travel benefit and that violated their rights either under the ADA or the Pregnancy Discrimination Act. And they'll get their right to sue letter from the EEOC, and then they'll be off to the races in litigation. I think there are a number of very strong legal arguments that these individuals would have to overcome if they wanted to actually prevail in that theory. I think the biggest one is it's a rather rare medical occurrence where you can't access medical care in your state, and so you need to go to another state to access medical care. I know a lot of employers are dealing with this in the transgender benefit space, but those are really two issues where states are restricting medical access. Generally, if you're pregnant, you can get care right in the state you're at, so there's no reason for a travel benefit. So that's a pretty strong argument. I know we don't have much time left, but I will pause because Ben has some really awesome stuff to go over, and I want to make sure he has a chance to get to it.
Yeah, thanks, Sam. And I think that EEOC stuff is significant because it's something that, you know, a number of organizations we work with got the Gustafson letter and got freaked out by it, but it's something that everybody's watching because, you know, if there is liability there, that certainly could influence how employers structure the benefit. So cautiously optimistic, I think, is characterization, but wait and see what plays out. So we just want to close out by reminding everybody that we do have a number of resources out addressing all of these types of things. We have a landing page, a reproductive health landing page, which is available at the Seyfarth, Seyfarth.com homepage. And if you go there, you can see the various resources we have on tap to help you navigate the landscape here, including legal updates, blog posts. We have a podcast now that's got a lot of different episodes, including one on this topic, and recordings of our prior webinar. I think this is our third, Diane, if I'm not mistaken, with likely more to come depending on the landscape. So stay tuned there. And we have a reproductive health tracker that is free of charge. You can sign up through that landing page I just talked about, which we're updating as these new developments occur, including the election, et cetera. So it's a great tool, and it's got a focus on things that are important with regard to these laws for employers, you know, so state enforcement action against employers, et cetera. Finally, in the moment you've all been waiting for, CLE code for today's session is SS as in Seyfarth Shaw 6291, SS 6291. So with that, I see we've got a question about CLE code, which hopefully I just addressed. But with that, we've got maybe a minute or two to try and take some questions. I know we've been trying to hit on them as we go, but I'll turn it back to the moderator here to give you instructions on how to do that if you're interested.
All right. So to ask a question via the web presentation, just type your question into the Q&A text box on your screen and press enter. The question will appear here on this side. So again, just type your question into the Q&A box that you see on your screen. Looks like we do have some questions in now. I know that you've actually addressed some of these. So, are there any of the questions that are there that you sort of touched on earlier that you would like to revisit? I don't believe that any new questions have come in the last few minutes.
Yeah, no, I think we hit on these or tried to hit on these as we were going through the materials. So, at the risk of cutting anybody off who's frantically typing right now, don't see any more. So I don't know, Diane, if you want to take us home here.
Yeah, I think just thanks for joining us. We'll periodically be scheduling more webinars as, especially as we start seeing either enforcement activity occurring or, you know, federal action or state action, and we accumulate enough material, we'll come back to you again. But you'll be able to get a recording of this webinar eventually on that landing page Ben mentioned. All the attendees will be getting this deck emailed to you after the conclusion of the webinar. So, please feel free to reach out directly if you do have any questions.
All right. Well, with that, we're ready to conclude today's webinar. We would like to thank you very much for attending. To end the call, just close your browser or hang up your phone. Thank you once again, and have a great day.